This video contains excerpts from an online workshop that the US-Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by US-Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
The first issue that we're going to talk about in terms of this data that exists in the world becoming evidence in an actual case is authentication. And authentication, as a term that's used in United States evidence law, simply means that the proponent of evidence, the person who is trying to introduce the evidence in a case, has to prove that the thing, whether it's testimony or a document or an object, is what the proponent claims it is. So if I'm trying to say that this is an email that John Ellis sent on April 6th, that's what needs to be authenticated, that John Ellis authored this email on April 6th, and that this thing that I want the jury or the judge to see is actually that. How do you go about authenticating something? It's a low bar for how much proof you have to offer for whether something is actually, the web page you're claiming it is. But you do have to offer some proof. Sometimes the way that you do that is through the testimony of a witness, or to bring in somebody, a records custodian, or somebody who actually knows something about how records are kept, and you actually put them on the witness stand. That is expensive, to bring in live witnesses to have to authenticate something. And so in the United States, we actually have a list of documents that are called self-authenticating. And before 2017, that list really only included things like, sealed birth certificates, other public records that we take as presumptively what they claim to be. But when it came to machine-generated or electronically stored information, litigants really had to spend a lot of money trying to authenticate this type of digital evidence. And so in 2017, there were two different categories that were added to the list of self-authenticating documents.
So this is Zia Vandenborn. She is an artist from Amsterdam, and she told all of her thousands of followers on Facebook that she was going on a 2-month trip to East Asia. And as she was there, she began posting pictures of her adventure. There was a picture of her snorkeling, a picture of her walking on the beach, and then a picture of her standing in the water throwing up the peace sign. She spread these photographs and these stories out over approximately a 2-month period. And at the end of it, she told everyone the truth. It wasn't real. She had simply taken photographs of herself, and she photoshopped herself into all of the pictures that she had taken. So as you go through, you can see that she even included the shadow, an empty beach where she put herself, and then finally, she put herself underwater. This happened 6 years ago, and by today's technology, this is a fairly crude way to add items to a photograph. This was done by hand. It took a lot of time. There are sometimes ways from a forensic standpoint that we can go back and determine whether or not these are actually fake. But the technology has gotten so much better over the last few years. Study these 3 people and tell me, which one of them is not real? Well, here's what I want to tell you. Not one of these people is real. All of these photographs were generated using AI. There is a computer system out there that was created that tries to determine what people look like based on photographs it's seen in the past. This is very scary for a lot of reasons, because how would one go and determine whether or not this is a real photograph or not? The interesting answer is that we use AI to fight AI. The technical term for this in the United States is called a deep fake. And a deep fake means an image or video or audio that appears to be something that it is not. How are we going to be able to educate the court, opposing counsel, and jurors about whether or not an item is what the person says it is? The term that judges use in the United States is objections to authenticity go to weight, not admissibility. Meaning, yeah, you think that's not a real picture, that's fine. The jury can see it, and then they can determine what, if any, weight or if they should care about it at all. And that can't be the right standard with digital evidence moving forward, because most of you believed that at least one of these people was a real person. How does it feel to know that none of them are real? This is by a website called thispersondoesnotexist.com. It's for this reason that when we talk about authentication, it is important and it has to mean something to us.
Even though machine generated and electronically stored information can now be authenticated without live testimony, you still need some sort of certification by some qualified person, somebody who understands the program, somebody who has inputted the data into the algorithm, to explain that the process produces an accurate result, but you're still relying on that qualified person. And the comments to this new rule make clear authentication is only the first step, and you can still dispute at trial whether something is what it claims to be. But the fact finder will see it, and if the fact finder believes it, then those credibility determinations are pretty much off limits on appeal and are pretty final. Again, 13 relates to records that are generated by machines. And so imagine a timestamp on a photograph, a Windows registry on a computer that lists the point at which certain drives, like a USB drive, are taken out of the computer, such metadata related to text messages and when they were sent. That type of metadata is created by a machine, not a person. 902.14 deals with evidence that is copied from a device, electronically stored information. So imagine text messages where what you're really trying to say is, this is the text that John sent me. Maybe the timestamp was machine generated, but the text itself was written by John. And so you can show that through circumstantial evidence as well. I was in an exchange with John at the time. I know the sort of words that he uses in the texts and emails that he sends me, that sort of thing. A forensic copy of phone contents. You'd have to have a qualified witness to give a certification, not through live testimony, but at least a certification that says this is a true copy of what I found on the suspect's phone.
if in discovery you provided a photograph to me, one of the things we would take is a hash value, and I'll explain that in a moment. If I was to alter any part of the photograph, let's say I was to Photoshop out something or Photoshop something in, it'll change the nature of the hash value of that photograph, and so we'll know that there's a change. 902.14 really gets to the file level and a folder level. So if I was to provide Andrea right now an entire folder or hard drive with discovery on it, I could take a hash value of it, and then later if she claimed that I gave her something or did not give her something, then we could go back and do an additional hash analysis and figure out if that was accurate. So let me just walk through how this happens or how this works. So if we started with something simple like John, if I put the word John through a hash function, it's going to give me a hash value. So a hash function is just a mathematical formula. It's really, in this case, because this is digital, it's looking at all the digital part of John, the ones and zeros at the byte level, and is then calculating a unique number for that. So you can see John has one value, but if we do John won a big trial, then the hash value is completely different than John. But look what happens in the third example. Just changing a capital J to a lowercase j completely changes the hash value to be completely different. Now, theoretically, no two digital items could have the same hash value. I say theoretically because there have been a lot of experiments to try to prove if you could have two documents that were different that had the same hash value. Generally, in the real world, we cannot make that happen. But there is a way that has been proved in a laboratory, and it's called cache crashing, where you could have two separate photographs, for instance, that had the same hash value. That is so theoretical that hash values are now used as to prove evidentiary integrity. So I can prove that the picture that I gave to Andrea is the same as the picture that we're introducing into evidence at trial. Same thing with large data sets. This is often used to make that determination. This is also used in big data cases where you can go through, and if we're trying to figure out if we received the same file on more than one occasion, we do a hash analysis and then compare the hash values so we don't have to look at every page within a large discovery set. So this is something that has both a forensic significance, but also a discovery and evidence significance as well. And the great thing about hash values is it's looking at, for instance, if we're looking at a document, what it's looking at is the content of the letter. So here if we have, "Dear Judge, I confess, forgive me, John." Well, if I was to name this confession as the document, then it's going to have a hash value. But if I name it denial, it'll still have the same hash value. So I named it confession, one hash value. I name it denial, it has the same one. Because when we're doing the hash analysis, it doesn't care about the title, it only cares about the contents. And that's true for other metadata associated with this also. And metadata is obviously just data about data. An example would be the date it was created, the date it was modified, the date it was last printed, etc. When we're doing a hash analysis, the program doesn't care anything about that. It's only looking for the content. And so that is an example of an algorithm, but one that is really well accepted within the community.
John, I actually have a question. So does that mean that there's really no way currently for somebody to tinker with the hash value to make it seem as if they know that this hash value is associated with a file they shouldn't have, like an image of a child, a sexual image of a child, they can't tinker with it after the fact to try to scrub it somehow from their computer?
Yeah, that's one of the areas that's used most commonly in the United States. It's in exploitation cases, and the government has a list of known photographs that are contraband or illegal, and they have all of the hash values for those. and they routinely go through websites to look to see if that hash value of that image exists in an email, on a website, or in a text message. And when they find that there is a hash match, then they generally are confident that that means that the image they're going to look at is the contraband image. There are theoretical limitations to this, but generally speaking, it's good. There are different types of hash values. This is a simple one. This is a 32-bit. Most of the ones we're dealing with now are a minimum of 256. Wow. And so that's SHA-256 or secure hash value. So there are a lot of different types out there. For instance, when you're banking, most banks have a minimum of using SHA-256, but that continues to increase. So the more complex the number is, that gives us more certainty that there is a match. But there are different levels of hash. This is just a simple one.
How does this play out in practice?
902.14 was really necessary. And where it came about is, if we're getting ready and we're in the discovery process and you have a Word document, and I would say, I want the Word document, and you would say, no, I'm going to give it to you as a PDF because I don't want you to be able to make changes. And I would say, you can trust me, I'm not going to make changes, but look, I really need this because I want to figure out more things like, when did you start writing it? When did you last print it? Were you using track changes? I want to be able to see the original document. And so for far too long, the reason opposing counsel would have refused to give the native file format was, well, you could make changes. So what's great about 902.14 is you can say, look, we'll hash it. If you made any changes, we'll figure it out. So that, I think, was a good reason. My concern about 902.13 is this. I think, one, it's meant to save money. And I think it's great in a civil case because, experts are expensive. And if you're going to have to pay someone hundreds of dollars an hour to, come to court and to testify, that is very expensive. And one of the ideas between 902.13 is you could just have an expert write essentially a declaration, prove that they were certified, and then they would enter that instead of live testimony. I think in practice it's really difficult and wrong, but I would say, just even from a more practical standpoint, there's a lot of dispute about what some of the terms mean in 902.13. It's going to take a while for those to play out in court. I think that means, though, the flip side is that criminal defendants, could introduce that evidence because we don't have the same restrictions. But we will be talking more about the Sixth Amendment a little bit later on.
Even the advisory committee notes to those two rules make clear that the proponent of that sort of digital evidence still has to prove that it meets the other requirements for admissibility, not just the Sixth Amendment, that it wouldn't violate the right of confrontation that John mentioned, but also that it is relevant, that it tends to prove something that matters in the case, that it is not hearsay, which is a rule of evidence that it has similar purposes to the confrontation rule, but is applicable in both civil and criminal cases and applies to the criminal defendant as well.
It's not uncommon now for us to have a case with hundreds of digital devices. I have a case right now where the government in one search warrant seized over 150 digital devices and included everything from computers to iPads to cell phones to thumb drives. It is a lot of data. And again, a lot of it was duplicative. But even in our standard case, where does data live? If you have a phone, then you probably also, or you might have a computer, you might have an iPad, and those sources could be duplicated on there. But what about the cloud? So often that we can get data on the cloud and we don't even have to have the device itself.
Yeah, so one issue that comes up when you are seeking information from an online platform, you want to ask Facebook, Google for a number of emails that were sent from one person to another, or you want Facebook to give you information about social media posts from a alleged victim in a case, let's say. Another example recently with respect to something called spoof card, a defendant in a recent case essentially was able to prove his innocence. He allegedly, according to, I think it was an ex-girlfriend, who had accused him of sending her threatening text messages and such. And he denied it, and he was able to get data from the company spoof card to show that she actually sent the messages to herself, and that she used this application to basically disguise which number it was coming from so that it would not look like she was the one who had sent them. But the only reason that that defendant was able to prove his innocence in that way and get the case dismissed was that spoof card was willing to turn over that data. When it comes to discovery in a case, that relates to getting information from the government. You just need to ask the government for it. And if they don't give it to you, you can ask a judge to enforce that. And the federal rule of criminal procedure that governs discovery of this sort of thing is Rule 16. And basically every state in the US has some sort of analog to Rule 16 that looks similar. So, for example, you have the right to seek reports of examinations and tests that are in the possession of the government, that are either material to the defense or that the government intends to introduce at trial. Also, with respect to expert witnesses, if the government plans to call a digital expert to the stand, you have a right to information. In a criminal case, believe it or not, you don't have a right to as much information as you do in a civil case. And I think John has been working on some discovery reform along those lines. And so there's an actual amendment to 16, but you have a right to a summary of the expert's testimony, the expert's qualifications. But in terms of the limitations of Rule 16, it's not a constitutional requirement. This is basically a law, a statute that it's a court rule. It's reciprocal, which means that the government can also ask for this information from the defense, get a summary of a defense witness's, expert witness's testimony. And what if it's not in the possession of the government? So you can't use Rule 16 to get information from Facebook or Google or Snapchat. So what do? You may have to seek a court order called a subpoena. And there are a few problems with respect to defendants subpoenaing information from these companies. And I should say that when the government wants information from Facebook, they've got a couple of options in front of them. They can seek a warrant, which is an order from a judge that is signed based on an affidavit that the police submit. They have to show probable cause that some evidence relevant to a crime is going to be found where they're going to search. And if they get a warrant, Facebook basically has to comply. But they also can just seek a subpoena. They can just subpoena the records without even getting a warrant. There is, in order to subpoena something, it generally just has to be material. It has to be relevant to the preparation of the case at trial and the issues in the case. But when it comes to electronic data and electronic communications, there are privacy statutes that limit the ability, especially of the defense, from getting this sort of information from Facebook and Google. So let me just give you an example. So the Electronic Communications Privacy Act, I think, which was passed in 1986, essentially, there's a bunch of digital evidence in a case, but how does it actually come to you? If you're a criminal defense attorney or a judge or a prosecutor, it typically comes to you in the form of a report from a digital forensic expert or software.
So when we think about forensic evidence, I want to move from, we talk about you get a phone or you get a computer, what happens next? What generally happens in criminal and civil courts in the United States is someone will take the device and they will use a forensic process, which I'll explain, to get information off of the device. So when we use the term forensic, we're really meaning using the term in a scientific way, that someone is going to get information off of the device and do so in a way that won't harm it. That's one of the concerns we always have, especially with digital, is if you were to take your phone and turn it on and look at a couple of things and turn it off, that would change the characteristic of your phone. So if I later got your phone and took all the data off of it, things would be different. And so we always want to make sure that we do things in a forensically sound way. With digital forensics, what that generally means is it's going to go through this process where first data is extracted from the device, and then there is an analytical part of it where there is analysis done. And then from there, we have to convert that in a way that people who don't have the $10,000 software can interact with it. And that's where reports come in. Reports are great, but they can be problematic. And I just want to give you a couple of examples right now. If I was to come into your house right now and you were nice enough or naive enough to let me copy everything off of your computer, if I copied everything that you had off your computer, I would never be able to reduce all of that to a report. What would you do with an executable file or with a program file? Those don't really reduce to paper or to other types of reports. So not everything is going to be there. When it comes to mobile devices, though, like cell phones, we know that we don't get everything off of the phone when we extract data from it. And so there are limitations. The first thing is I'm not going to be able to get all the data off of your phone. And secondly, not all the data on your phones can be reduced to a report or a writing. So it's one, knowing that there are limitations. And the second thing is knowing that there are certain limitations built into the system itself. There are different ways, different techniques or methods or tools I could use to get some of the data, a lot of the data, or most of the data. And so it's just knowing that when you look at these reports, never assume that this report contains everything that was on the device. Secondly, the report itself is only as good as the person who was using the tools, which we're going to talk about more in a moment. And sort of the third thing is that just because you have this report, the main thing is there could be more data out there. This might come up in a situation including where you see a text message. If you don't see other text messages, does that mean they weren't there? And a lot of times we begin with the assumption that just because we don't see it doesn't mean it didn't exist. So there's a lot of questioning that has to go into these reports. Don't fall into the trap of thinking that reports are perfect.